All right, everybody, we're going to get started. I want to welcome our speakers, our panelists, Marvin Johnson and Paul Monicati. And before we go, I want to thank Jennifer for her leadership this past year. She is relieved of that duty tomorrow morning. And I think that we should also remember that Jennifer was a state bar president and did a lot of wonderful things that I have personal experience with. And so Jennifer is quiet sometimes and modest sometimes and should be thanked profusely. So Jennifer, thank you. All right, Marvin Johnson and Paul Monicati are two outstanding ADR practitioners who each bring unique background experiences to us today. So I'm going to start with Marvin. Marvin is a nationally recognized mediator, lots of awards and national organizations. You can read his resume and his bio in your materials. But I think one of the more interesting things, and there are several, is that 3 presidents of the United States, a secretary of the United States Department of State, the governor of Maryland, a chief judge of the Maryland Court of Appeals, have recognized Marvin's expert, pointed him to organizations such as the Federal Service Impasses Panel. I think you can guess what he does in the sense of the cases that come to him. He can talk about that, but just an amazing background with ADR. Paul Monicati is a well-recognized and respected ADR practitioner. We know him for 2 major cases, but he's also been involved in many others, of course. He was the court-appointed settlement master regarding a couple of the Flint water contamination cases, and also was involved in the huge Dow Corning breast implant insurance coverage litigation a few years ago. So they each bring interesting background, to say the least. And what we're going to do today, just so the format's clear, is we'll have a conversation. We'll have a conversation. Paul and Marvin will talk about their experience and about the pieces of the mediation process so that we will get to the impasse issue. Keep in mind, just a note, not everybody uses the word impasse. Some folks call it something else. We can call it a bump on the road. Maybe there's no such thing as impasse. Depends on your attitude and your point of view. So let me start a little bit with Marvin. Marvin, tell us a little bit about you that I haven't said. Just a little bit about your background, what you would like us to know that I haven't disclosed.
Well, you gave a pretty good overview. I've been in the employment area ever since graduate school. My master's is in the what they call back then industrial labor relations area. That's what my degree is in years ago. So that's where I started out, and only because parties, I guess, been word of mouth, parties got word of my expertise. And so I started mediating in areas other than employment. And that's been a good thing because I think mediation skills don't change from area to area. And so that's how I've broadened my fields in terms of which I do my work. Other than that, you said it, and I'll just mention it briefly. My skills have been recognized by, the governor of the state of Maryland and some presidents of the United States, and I really appreciate that. That has enhanced the work that I do, also my reputation.
Paul?
Thank you, Michael. And thank you for the invitation to speak with this group today. and also to participate in this discussion with my good friend Marvin Johnson. I was very encouraged to hear the remarks from the Chief Justice and the President of the State Bar in support of the ADR movement. That's heartening to me, and I'm sure everybody else. Just briefly on background, I started out working in the court system. I went to night school in Detroit, went to night school for 4 years and had full-time job in the court system for 3.5 of those years, and gave me the opportunity to see firsthand in the trenches the court system, the efficiencies and inefficiencies of the court system. Gave me the opportunity to meet many lawyers and clients, and that helped me when I got out into practice in 1978. I knew all the judges back then. You can't possibly do that now. And so I got a lot of what I would call quasi ADR assignments as referee, umpire. I did some refereeing in juvenile or probate court, I should say, on claims, contested claims. And I started arbitrating in 1983 and then mediating in 1986, and was really fortunate to be in a position where there really wasn't much competition. And if you wanted to mediate, like it or not, you had to mediate with me. So I had a lot of experience in all kinds of cases that really, I think, prepared me for the cases that you mentioned, Mike, the Dow Corning insurance coverage, as well as a couple of Flint assignments. I'm a solo practitioner and have been that way. I've never worked for anybody once I got out of law school and stopped working for judges. So whatever I've done has been on my own with help from others, and it's been a great ride, and I hope to continue it at least until I'm 80 and beyond that. We had an off-camera discussion about mediators and when it's time to retire, and you asked my wife, Patty, she knows I don't plan to retire, and I hope I don't stay on too long. So thank you, Michael, for that opportunity to explain it.
So let's talk about the beginning of a mediation. And Paul, I'm interested in what you think is important. And then of course Marvin will pipe in, and feel free to interrupt each other, but or respond to each other. But Paul, what's important to you at the beginning of a mediation that you think kind of sets the tone and serves well when you come to the bumps in the road?
Sure. I think first and foremost, Mike, what's important is to, at least in my approach to things, I gather, I'll call it intel, but background information on the participants. I want to know who I'm dealing with, and for purposes of, storing it in the back of my mind, my memory palace, like Hannibal Lecter did in Silence of the Lambs. He talked about the memory palace that you file things away for future use. So I try and find out, even before any mediation starts, before I even meet with anybody, even by phone, some background to store for later use during a mediation, either during downtime or when we get to some tense moments. I also try and make pre-mediation phone calls with counsel to get background, and certainly to start establishing the rapport that I need to try and carry on a mediation successfully. I try and engage counsel in co-designing the process. I mean, we all know the standard process that's used in mediation, but the beauty of mediation is it's so adaptable and customizable, so to suit the needs of a particular case. And I want to engage the council in that, giving them some sort of a stake in the success of the mediation. So it may not guarantee success, but now they're responsible for part of the process that's going forward. I try and identify all the necessary people we need in a mediation, not only the named parties, but unnamed stakeholders, people that I call significant others, which I want to be at the eventual mediation. That could be somebody as simple as a spouse of a party or a financial advisor, a minister. I've had all kinds of significant others, a brother, a parent, a sister. I want to make sure that everybody's at the table and we're not dealing behind the scenes with anybody that can later on scuttle a mediation. I got a couple of other comments and then I'll turn it over to Marvin. I want to make sure that we identify and name the client decision makers with full and binding settlement authority. I want those people to be involved in the mediation. I don't want to dry run in a mediation. It's not fair to counsel, it's not fair to the parties, and it's not fair to me. So I want decision-making binding settlement authority, of course, given, I suppose, what the issues in the case are and the money involved. And I think maybe getting to last but not least, I make a real effort to discourage lawyers from using the typical adversarial, argumentative, and sometimes accusatorial pre-mediation statements that are pretty prevalent today. If they're going to do that, I just assume they send me stuff that's already in existence. Don't waste your client's time on that kind of approach. We even suggest a brief, and I really mean brief, for the lawyers in the group, 2 or 3 page synopsis with incomplete sentences, incomplete paragraphs addressing, and no really detail addressing some specific items. So I don't want people to poison the well from where they've got to drink later. And I think lawyers are better off spending their time and their clients' money preparing the clients for an effective mediation than to send out these combative, unproductive pre-mediation summaries. The last thing is I try and remind them, bring your term sheets and your standard settlement agreements. I want them to be thinking at the very beginning, before the mediation even starts, about settlement, resolution, and what they'd want in a resolution. So that's all before the mediation even starts, Michael.
Thank you. Marvin, what do you do?
Well, I, like Paul, I talk to the parties before the session jointly for their expectations, the familiarity, because people, well, mediators don't do the process the same. And so I want to know their experience they've had, and then I tell them my expectations. And we have a discussion about how we're going to proceed, what the process looks like, and we go forward from there. I tell them that I may circle back with another conversation if need be, that I'll talk with them separately, and I may circle back depending on what I've learned from having that separate conversation. But typically, that's what I do before I get started with the parties. It's not very complicated. I try not to, I'm not one that that's, trying to act like a judge being in full control, because it's really their outcome. They got to live with it. And it's really their process. I try to set up the process with their input so that they're engaged and they're satisfied with it, and they'll be satisfied with the outcome as well.
Michael, if I might ask Marvin a follow-up, if I understood Marvin correctly, he does that sort of introductory discussion on expectations with everybody jointly, whereas I kind of approach it on an ex-parte basis. So I'm real interested in hearing from Marvin why he thinks doing it jointly is better, if I understood you correctly, Marvin.
So I do it both ways. I talk to them separately, and then we come together and we talk jointly.
Okay.
You know, we talk separately. I talk to them separately to see if there's anything that's really outside of the parameters, or it's going to be a surprise. I want to know, you know, have they been in a mediation before? Have they been in a mediation like I am going to proceed with? And then try to get that straightened out. I might come back to them again jointly or not, depending on what I learn, and then we roll out the process.
So I gather from both of you that you have potentially different ways, but you do try to establish some relationship with the parties and the lawyers. Is that a fair statement?
Absolutely. That's key. Michael, if I had to boil it down to keys to success, I think one thing is the connections, finding and looking for connections and rapport, establishing rapport and beginning to establish a relationship and trust and confidence. That is key. And if you can the more personal you can make it in terms of your own personal revelations, that's even better.
Yeah, I would think early on, it probably still goes on, but I don't get them as much. You get appointed to a case, and you may or may not be familiar with the lawyers or the parties. For me now, I'm typically, selected by the parties. They know who I am, they know my reputation, and they call me, or someone calls me and asks if I would be willing to mediate a particular case with them. So it's kind of shifted away, and I guess because of my experience and what I've done, I don't get the typical cases where I don't know the parties, I don't know anything. I may not know the parties, but the parties either know me or they heard about me, and they call me to help them resolve whatever dispute they have.
Michael, if it's all right, if I wanted to maybe stress the importance of this, finding personal connections and trying to establish rapport. A very close friend of Marvin and mine, Jeffrey Krivis in California, passed away recently, and there's been a couple of memorials for him. One was funeral, and the other was a celebration of life. And Jeff was one of the most successful mediators in the world, and I'm not exaggerating, in the world. And I heard two eulogies, one from a plaintiff lawyer and one from a defense lawyer, when they first met Jeff Krivis and showed up at his office in Encino, California. These two lawyers, I know them both well. Hyper energetic, type A personalities to the hilt. They were loaded for bear when they showed up at Jeff's office and were ready to start talking about the case. And Jeff spent, I bet, 20 minutes to a half hour that both of them complained about, showing them around his office, showing them knickknacks, baseballs, music, guitars, you name it, everything but the case. And these two were still chomping at the bit. When are we going to talk about the case? And Jeff understood that the case isn't necessarily about the legal and factual issues. It's about real people. And I think both of those lawyers left the mediation. They were successful. They thought, I don't like this. I don't like this process. Yet they both kept coming back to Jeff, and one became eventually a very famous mediator. So that should drive the point home. That was one of Jeff's keys to success, recognizing it's about people.
So look, I want to talk just for a second about mediation statements, because I think, Paul, you certainly alluded to it. Marvin, do you ask the parties to do a mediation statement?
No, I don't. I don't ask them to. If they prefer, if both of them would like to, then I will accept them. But I don't ask them to do that because there's pluses and minuses in them. Because what it could do is it could reinforce the rigid position that they have. They're stating it over again or putting it in writing. I don't want that. The plus you can get out of it from the mediation standpoint, you can get the history. But you can get that. There's other ways to be able to get that history to do it. Those mediators who are pretty confident, you can do it. You can learn as you go in the actual mediation process, or you can have a separate session and gather that information.
So you gather your facts that you need just beginning with the pre-meet phone calls?
Yes, yes. What I found is that, as Paul said, it's about the interaction of the parties, and it's about people. So if I can gather some things through my pre-mediation conference calls and talk to the parties, I have something to lead into and to move them to begin to move them through the process.
Paul, you must have had some experiences that led you to your position on mediation statements. Is that a fair statement?
Yes, I'm not quite as confident as Marvin is, and I do want something ahead of time, but so many times mediations have started out on the wrong foot because of these combative pre-mediation statements. And we have a memo we send out to the parties, as I referred to before, about send me incomplete sentences and paragraphs. I don't want detailed debate or argument. Less is more, in my opinion. And don't send me, although I don't say this, I don't think, in our pre-mediation correspondence, summary disposition briefs are useless. I think that poisons, it runs the risk of further polarizing the people, but it can be helpful to give some background if that's what they're really doing. I'd rather have that than counsel to repurpose a brief into a mediation statement that is only further polarizing. I will give you something about my philosophy. I don't put a lot of stake or reliance on pre-mediation statements anyway. It helps me get up to speed, but I can't remember the last time I ever read anything in a pre-mediation statement that I hadn't already heard before and was familiar with. The next thing is, when we do a joint session, which I advocate, and I have kept people in joint sessions for days or weeks in different cases, I don't put a lot of stock in what they say in the joint session either, if we use it. And sometimes you got to script a joint session so it doesn't go south on you. There's techniques to use for that, but I really don't find out really what is the obstacle or the hurdles that we need to focus on until we get to private caucus. And then that's usually when people let their hair down. Funny coming from me with no hair, but so it's all a process, but you really don't get to the meat of it until you're talking to them privately. So I go out of my way saying, don't waste time and money sending me stuff that's unproductive. And in fact, in joint sessions, there's very few things, if we do that I haven't heard before. So let's try and be positive in your statements. and in your pre-mediation summaries.
Sounds to me like an important part of the process both of you were talking about is doing your best to avoid an invitation to be confrontational. Is that fair?
Definitely.
Yeah. Yeah, you don't want the mediator to be confrontational, although there could be times that you could be a little stern about something. But if you're confrontational, you might, what they used to say when I was at Federal Mediation and Conciliation Service, break your pick. And that breaking your pick means that you can't do anything else with them because you spent your wad, you said something you shouldn't say, and so you can't do anything more. And you got to let somebody else come in and take over the case.
So I have a question here. Given what you've both said about mediation statements, Marvin, you've indicated you don't use them, you don't ask for them.
I don't ask for them. If the parties want to, yeah.
Right. But Paul, you have a very definite process. Your bullet points, I think you've called it before. So here's a question. What do you do about parties who want to attach everything under the sun to these statements? Deposition testimony, contracts, other pretrial documents. You know what I'm talking about. What do you do with that?
Can I say something before Paul responds? And that's why I don't do it, because in one case, I got boxes, just boxes of stuff from one party about the case, and that's where I learned my lessons that I've got to put some limits on. If they're gonna give me something, I got to put some limits on it. So go ahead, Paul.
Well, I remind the parties that mediators get paid by the hour. If they want to send us hours of work, that's fine. I'm being slightly facetious because I'll pick and choose, like we all do, what we think is appropriate. And when you get a box or when you get a stack of documents, I am always amazed, Michael and Marvin, and maybe your experience is the same, that 95% of that never is even mentioned, is never even referred to in caucus or sometimes even in a joint session. So I pick and choose on it, but if it's important, I'll spend the time reading it and billing them for it. I bill, and I don't know what Marvin does. I bill for prep work and for mediation work. And if they want me to spend hours prepping, I'll do it, except those lawyers that send those summaries in, and there's a lot of them, on the day before a mediation. I've even had summaries come in after midnight before on the day of mediation or in the morning at 7 a.m. You can forget about it, is what I'd like to say, but I still will read it. If I have to scan it, I'll do it, but I can't spend time on it, the morning of a mediation.
So you're both working hard to make sure that things move along smoothly. You've worked hard to establish your relationships with the parties and the lawyers, but sometimes that doesn't get you all the way home. So what do you do when the parties come to you and say, we've hit a wall, we're at impasse, I'm going to get my coat, I'm out of here? What do you do?
Marvin, I'll defer to you at this point. Before you start, Marvin, I do want to stress to everybody who's listening, and Marvin's practice is as similar as mine. We don't advertise. We get most of our work word of mouth.
Right.
So it's probably unusual situation when we don't know one or all of the lawyers involved. And that helps things, as if they're repeat flyers with us, that saves some of the the groundwork that we have to do, Michael. It's not in every case that we have to go through this, but when we get something, when we don't know them. That's what we do. And I do a lot of prep work at mediation before we start with clients. And I'm very client oriented, but I want to hear what Marvin has to say about, okay, you hit a bump in the road. Now what the heck are you going to do?
Yeah, well, typically people, I'm sure this is with you too, people call you because they trust you. They know you're pretty good at your craft and what you do. So that if either jointly or in a caucus, if you say something that they should consider, or that this is going to take a little longer, they will listen to you and allow you to, what they say, work your magic or do what you need to do to get to the resolution. But if you have folks who don't trust you, don't know you, you've, as Paul indicated, you've got to before, I think before you get started and even during, you've got to get the parties, either one or both, to trust you, because you're going to have some you're going to make some judgments and ask them to do some things that they may not be willing to do. Like I think you mentioned, they want to walk out the door and you have to say, well, I see we're making some progress here, and I think there's room for us to get an agreement. So I would hope that you won't do that now. Give me some time to talk to the other party. I'll get back to you. So if they trust you, they will allow you the room to work with each side to get them to resolution. And there's always, it's darkness before the dawn, that statement. There's always places where it doesn't look like it's going to work out. But if you hang in there and you work with them, you can get a resolution. I'm never going to say, I know it's not true that I got 100%, but it's really, really, it's high. It's really high 80s, 90s in terms of what I do. And sometimes we have to come back to do another time, get the scheduling out and have another session. Give me time to work with the parties separately before we go back and have another session.
Paul, what do you do?
Working backwards from what Marvin said, my style is I'm driven to get a dispute resolved in one session, whether we get it done by 4 or 5 o'clock in the afternoon or midnight. I don't want the clients to have to go through this again because it is difficult. And I do mediate all kinds of cases, whether it's a personal injury up to a big commercial corporation. I don't want people to have to go through that again. I don't want to lose any momentum that we've worked all day to develop. So I'm reluctant to come back and do it again. So I try and at the beginning let people know, and I have done this before. If we have to do in the right case, if we have to do a marathon session, that's fine. We're going to get this done one way or the other today. So I press that, and I try and address it early, as I said, by trying to convince the participants that in mediation, patience is a virtue. It's a process. You have to let the process unfold, and you have to give it enough time to work. As Marvin said, it's magic. It's like learning dance moves, the tango or any other dance. It takes 2 to tango. So you got to go through all the steps in order to complete the dance. And I can give it time permitting, I'll give you an example of what I tried to do just recently and how when I was faced with a very successful, driven corporate party who said that none of this patience, they're either going to agree to my terms or not. And I got a very important golf game in 3 hours, and I'm leaving in 2.5 hours, and I had to contend with that and was successful. I also try and always maintain an optimistic, positive mental attitude. Just like Marvin, I try and reinforce all the time, mostly with a straight face, that we're making progress. No matter how small, we're still making progress. So stick it out. You don't know how this is going to end. And then if I'm faced with somebody in a mediation who maybe is a little challenging, a little impatient, a little counterproductive, for want of a better term, then I will pay special attention to them, and I will try and do extra work to cultivate a relationship with them, and even try to maybe convert them somehow to being a mediation ally instead of an enemy. And I've done that before with success with somebody who could be a major impediment in a mediation. I'll focus extra attention on them.
Do you, either of you or both of you, kind of revisit some of the discussions that you had or might have had regarding risk analysis, for example? Do you go back and talk about the facts as they've been developed? Do you just have them sit back and give you an opportunity to discuss with them perhaps perspective? What do you do?
Well, I discourage getting into the factual and legal merits. I ask people when I'm, again, in that pre-mediation conference, before the mediation starts, tell me what your strategy is today. Are we going to be problem solving, or do we want to debate the factual and legal merits? And I'm fine with that. I'm prepared, and we can get into the weeds if you want, but I'm hoping that we're going to be focused on problem solving. And many times they will say that right away, and I know then we're going to be focused on problem solving, not the facts. Early in my career, I did focus a lot on the factual and legal issues, but as I got more experience, I'm getting away from that. But if they want to, I'm well prepared to do that. I want my time spent reading their summaries and preparing to get into the weeds to be wasted. I really want to focus on the future, not the past.
Yeah, in the pre-mediation meetings I have with them, sessions I have with them, as I said, I have them separate and then together, and maybe separate again, depending on the information, the intel that I get. Bottom line is, for me, is, why are you here? Are you here to resolve the case? Or is this just you're going through the motions? And most of the time they're here to resolve the case. And so if they're there to resolve the case, then let's move forward. Let's see where there's room to move. And if they prepared for this, a lot of them haven't, they have discussed where the movement is. And they may not state it in a joint session, but they may say it privately to the mediator. So to give me some information on, making some movement to get movement so that we can get to a resolution. And I think it's the psychology, Paul might talk a bit more about it, psychology, not walking in, putting everything on the table at the beginning because it looks like you're just giving up and you really want a settlement. So we have to do this dance with them. We have to do the dance with them because they don't want to appear that they want to settle. They want to be tough so that they can get the most for the client. And that's understandable, but you can still do that in a collaborative way if they took a mediation course of some sort. But in any event, we have to understand that and help them move through this process to get to a place where they're satisfied within, there's a, what's it, the zone of, what's it called? Zappa, the zone of, what's it called?
Zopa,
Zopa.
ZOPA.
Yeah, so there's a zone where if you get there, then you can get a resolution, and that's what we're looking for as a mediator, to get to that zone, and then let them decide where within that zone. The zone may be, it may be like a foot, it may be 6 inches, but when you get to that zone, it's like it's on them to decide, where they want to take it to get the resolution.
Well, do you spend time thinking about half a loaf versus a full loaf? In other words, do you spend time thinking about, well, the parties seem pretty entrenched. Are there other areas of, are there some partial settlements that could be pursued?
Sure.
Go ahead, Paul.
I don't think either Marvin or I give up easily. We're known for our persistence, and I don't like having that conversation. That's really when all else fails on it, to do a partial settlement. Michael, you asked about half a loaf, and that's fine. That's part of the mediation progress. When we get to that, and let's say that half of the loaf is half of the money that's wanted, Marvin and I probably both start looking for non-monetary, creative interests or trade-offs that can supplement the half a loaf. And if lawyers were preparing their clients in advance, they'd set them up for some kind of a mediation range, not a fixed number, and also find out from their clients, what is there something other than money that is of importance or usefulness to you. So we start looking for that, and I will in caucus, and if I have a flip chart, it's even better. Or putting it on a legal page. I've even done it on these little pads that you get when you're doing a mediation at a hotel, for example. I want the lawyer and the client to engage in brainstorming, where you just come up rapidly with a bunch of ideas, not that you're advocating or owning up to them, just to get them out on the board. And what impresses me most about that is it really gets their creative juices going. But some of the best ideas and solutions for that half a loaf comes from the clients, things that neither the lawyer never asked about or never appreciated, things that I didn't recognize. And you're hearing these great ideas you're putting up on the board, or you're talking about them, that give you sort of that opportunity to follow that way before you give up on something. You really got to brainstorm, and clients that are really good at coming up with creative ideas, I think. So
one of the the materials that are attached and available to our attendees include an article that you wrote. And does there come a point where you start talking about alternative dispute resolution devices?
Well, for me, when all else fails, and I mean that you've tried everything, and all of us on this screen know about impasse, so-called impasse breaking techniques. I don't think the word impasse is in Marvin's vocabulary or mine. If you're a traveler and you hit a dead end, well, what do? You don't give up and go home. You try and find another pathway to follow. So we'll try and do that and explore a lot of hypothetical what ifs and do our best. Bracketing and other things. That's not the purpose of our discussion, but I think what you wanted to know is when do we start talking about other alternatives? That's a last resort to me, Michael. And if we get to that point, often you got to fight because the parties are frustrated. They may be mad at us as mediators. They're probably mad at the other side, and they start name calling and the bad faith, insulting, and discouraging. There are methods to do that. So I keep trying to push them to stay in negotiation. One of our jobs as mediators is to keep parties talking long enough at the table, not leaving until at least the parties get to their best offers. That's not always easy, but let's see what the best offers are. And if they don't want to disclose it to Marvin or I, for publication purposes, what the heck? Marvin and I have spent all day trying to build trust and confidence. We're not the enemy. We're not trying to get one side or the other the best deal. Why don't you level with us? Say, let's try and make beneficial use of our time. Tell me in confidence how far you'd be willing to go today. And sometimes people will level with you. Heck, Marvin and I, I'm sure, have been let in conferences between the lawyer and the client when that very conversation is being discussed. What are we going to do? And we're not going to say anything. We're not going to reveal anything, but heck, we can be maybe a negotiation coach, or if nothing else, just a sounding board. What might do that? So I think that there's some ways to do that before you quote unquote give up. We don't give up easily before we resort to other methods.
Yeah, it's happened. I can't say it's happened majority of the time, but there's a number of times where it's happened where the attorney will talk to me privately and want me to help him talk to his client in terms of the range of resolution. It's not just the principle of the thing being stuck in it, and there are some alternatives to be discussed. I've done that a number of times. I don't want to say it's 50%, anything like that, but it's I would say 20% or so where the attorney is representing the client and can't get the client to understand, and wants the mediator, wants me to come in and just have a discussion about what are these options and what is the purpose of it. That's happened to me, like I said, if I had to guess, maybe 15, 20% of the time.
Mike, I'd like to make a plug in the right case for in-person mediation, because many of these breakthrough moments, in my experience, and I'm guessing Marvin's, have occurred not in the presence of everybody in a joint session or even in a caucus, but it happens in the hallway, or it happens, gosh, in the bathroom, where deals have been made in the bathroom, in the men's room, in my instance, and I'm sure in the ladies' room and other mediators' experience. And also for when you're in person, just meeting the client and talking to the client and trying to, at a turning point, distract them from what is the issue, and just sharing a personal moment with them, which you can't do on a Zoom. I mean, the lawyer and the client are there together. You're not working against the lawyer. You're trying to make a further connection with the client. I'm allergic to cigarette smoke. And I don't like being out in the cold weather, but I have followed clients outside in the wintertime in my sport coat to be with them when they're having a smoke or two. and some of the most candid conversations I've ever had with a client or a lawyer are outside when they're polluting the atmosphere and polluting my lungs. But to me, it's priceless, and it's worth the aggravation. To me, you can't do that remotely on Zoom.
All right, I have to, unfortunately, we've come to the end. Obviously, we could keep talking, and I hope we get that opportunity sometime. But thank you, Paul and Marvin. If I could just summarize, I think, is it Rita Moreno who said, as an actress, never give up. So if there's anything about impasse breaking, it's you keep trying, you build on your relationships, and you keep going forward. It's like a bumper car. You just keep going.
Right, Michael. I think keep in mind that a dispute in a case is always changing. Whether you get a new judge on it, new law, appellate rulings, newly discovered evidence, people just sometimes rest in reflection. There's always going to be changes. So you got to try and leave them that there's always hope because things can change.
Thank you both.
Thank you.
That brings us to the end.
Great to see you, Marvin.
Yeah, good to see you, Paul. Thank you.
Thanks, Michael.
Thanks, Michael.
It's a pleasure to meet you, Marvin, and it's always great to talk to Paul. Thank you, everybody. I understand that the next session starts at, if I have it right, 1:30. Do I have that right? I don't have the entire schedule in front of me.
Michael, you might want to just remind everybody that that article you referred to does spell out specific alternative processes. So you can get all of that from the article, I think, but the nuggets that Marvin gave and I tried to mention are really worthwhile in addition to that article.
So I think people can leave as they need to. I'm going to talk for a second because I've had this conversation with Paul as recently as yesterday. And it occurred to me, two things occurred to me, but it didn't happen right at the moment that we were talking. But Paul, when I think I called you and we started talking, and the first thing that you did was ask me about something that happened last week. Now, keep in mind, I called you to ask you or tell you something, but the first thing you did was engage me in a conversation about something we both had in common from last week. And I realized only later that what a technique you used, maybe not on purpose, but you did what you were talking about doing, building rapport, developing relationships, etc. We've known each other for a long time. But the other thing I would say is I feel pretty strongly about resuming face-to-face litigation, pieces of litigation, face-to-face motion practice. I think we're missing something, and developing relationships needs to happen face-to-face. I think that's the best way to do it. So for all those listening who are still there, I am a proponent of face-to-face motion practice. And I made the point last week at the event you and I were at for this. Marvin, do you do your mediations face-to-face or both?
I did because of the pandemic. I don't anymore, and I'm kind of the reverse. And I think, I don't know who said this, someone in the national scene said it, but once the door is open for things, it's hard to go back. So I've gotten used to this, and the value for me as I move toward retirement is I don't have to get on a plane because I mediate more than locally. All right, so anything east of the Mississippi, I was on planes and hotels, and it was it was fun for a while, but it gets old after a while. So the fact that I can do this through Zoom and everything is I think is a benefit to me. For those, there are people who don't like it, and I think they should go to doing face to face. But for me, I think I found my niche in it. I can do caucuses and otherwise in it. So I like it, and I think it allows me to continue to do this long after I, was gonna retire. I can do this in semi-retirement and still continue to work.
Yeah, I mean, I understand certainly there are practical issues. People from all over the world potentially can participate
Yeah.
in a more economical way. I mean, I did have one a few years ago where one of the parties was in China, and I don't know how if it would have happened that mediation could have occurred if we'd insisted on face to face, especially at the time in the middle of the pandemic that happened.
Right.
So I know that there are, pluses and minuses,
Exactly.
but as we're putting the pandemic behind us and there's more distance, I really want to see more collegiality, if you will. Dan, our most recent bar president wrote an article um, talking about collegiality and how it relates to professionalism. That parties who know each other and deal with each other face to face are going to be more likely to be more professional. Well, I feel the same way about the practice of ADR. That I do think if we know each other, there are kinds of communications that are more likely to take place if we're face to face. I mean, that's just my pitch. I don't know if it's going to happen. I don't know if anybody else agrees or disagrees, but that's kind of where I've come out.
Well, there are options. Someone put in the chat about some person might be intimidated if it's face to face and maybe not. And so these are options, and I think we should use them. We should use them
Well,
all where they're
there's no doubt,
beneficial and you can get results.
there's no doubt that in certain circumstances where there might be a power imbalance, for example, that the Zoom works better. And so I'm saying on a case by case basis,
Right.
you would look at that. And I think that it's one of the things you talk about at the very beginning when
Yep.
you first start talking to the parties, right? You're going to talk about, does it make sense to do this face to face? Or on the other hand, are there some reasons we should do it remotely? I mean, you talked about, Marvin, I think designing the process. The
Yes.
parties design the process.
Yes.
So let the parties tell you what they want to do. I agree with that. I agree, totally agree with that. So I don't know. I think we're done. And I appreciate everybody. I don't know who's listening. I can see folks who are still on, and thank you for sticking with us. But there is another session to get to, and I frankly am one of the people who wants to get to another session.
All right.
But,
Thanks everybody who joined us. Appreciate you.
Right.
Thanks, Jim.
Thank you. And I think Paul and Marvin, I really hope we can do this again, maybe in a different way. But I love listening to both of you. Marvin, it's great. I really wanted to ask all sorts of questions about the Impasse panel, but what wasn't really our core job today. And I'll
Right.
tell you, there's one more question I wanted to ask, which we can't get to, but it's question, Paul, that was asked last week by Doug Turing, and I thought it was a wonderful question. And what he asked was essentially, what has occurred during the mediation in addition to settlement, putting settlement aside, that leaves you satisfied with the mediation? In other words, what's another way to ask that question is what's the definition of success if, and assuming that that a settlement is a measure of success. What has occurred during the mediation that would say to you it's been a success?
Paul, I will say this, communication and interaction. That's the key to what we do. But go ahead, Paul, take it over.
Yeah, I would think that seeing that clients were fully informed of the risks and the alternatives and the consequences of non-settlement, that parties cooperated in sharing information. So at least they had all the information they needed to make an informed decision, whether it was to settle or not. That's fine. it doesn't have to settle, but you want to make sure the predicates are covered. I notice lawyers who, and remember lawyers who never use their, lose their composure, even if the clients do during the mediation. I think that is a successful mediation when at least the lawyers keep their cool. And I think that what I said before about at least making sure all the best offers, the parties get to the best offers before they leave, and that's disclosed. And last but not least, I like to see people leave and be cordial with each other and leave on good terms. Even if it doesn't settle, why can't you say, I appreciate your time and effort and professionalism, civility, and let's hope we can resolve it later instead of storming out separate rooms. That to me is success. They still have the relationship.
I agree with that. And I think we all know that many mediations settle after the day of mediation.
Right.
You get the phone call, we've had a chance to reflect and
right.
we can do something different or whatever.
It's
But
what I
if
call
you
a gallon
create-
wine. It's what I call a gallon wine, where they say we take no wine before it's time or something like that. No grape. So timing is everything. It might not be the right time, and you may have through the mediations opened up something to get them to talk and to resolve. So just because you don't get the settlement, that doesn't mean that it wasn't successful.
Yeah, it's wonderful. Guys, thanks so much. I'm not sure technically what I do other than leave.
I guess that's what we all
thanks,
do.
everybody.
Thank you, folks. Thanks for those of you listening, and thanks everybody involved.
Likewise.
Thanks,
All
guys.
right. Take care.